All right, this is our final panel, Emerging Music Issues in the Digital Ecosystem, the impact of digital media on soundtrack exploitation and film and TV music licensing. And this panel will be moderated by Jay Dougherty, who is a professor of law and the director of the Entertainment and Media Law Institute right here at Loyola Law School. He is also of counsel at Hogan Lovells LLP. In addition to decades of experience in film and media industries, he also has substantial music industry experience. His music experience includes Artista Records, A&M, and Slash Records, representing Captain Beefheart and Broadway music authors, and heading music business affairs of MGM and Morgan Creek. He's also been an active professional guitarist and singer-songwriter since the 60s. So without further ado, Jay.
Thank you, Patrick. Thank you all. I hope you're enjoying the day. I personally found these panels to be really interesting, and I hope that you'll find ours to be a good way to polish it off until we get to the refreshments afterwards, and I hope you can stick around for that too. I'm going to keep the introductions brief so we can have as much time as possible for the content. Our panel is going to discuss a set of topics that ranges from technological impacts on live performances to the cutting edge of licensing of digital uses of music. And I have three terrific panelists to help us through that conversation. I'm going to describe them very briefly, but I commend you to look at their bios for more detail. They're really terrific people with great experience. Bill Colitre, I'm pleased to say, was I think in the first class that graduated from Loyola that I had the pleasure of teaching a long time ago, and he's the Vice President and General Counsel of Music Reports, Inc. Among other things, he's a strategic consultant to their clients, and he heads the company's licensing and royalty services divisions and its business development lead. He's one of the most knowledgeable people out there that I'm aware of in terms of music licensing and digital music licensing. Next to Bill is Paul Friedman. Paul's Senior Vice President of the Music Affairs Group at Sony Pictures Entertainment, so he's music within the film and TV company, media company. He's responsible for their music transactions and handles the acquisition of music rights for all of their media. He also oversees music transactions involving new media outlets that exploit music content online, like Amazon, Google, YouTube, you know the list. The other, Rachel and Bill are both Loyola alums. Paul is an alum of the wonderful Tulane University Law School in Louisiana. On his left is Rachel Stilwell. Rachel is in private practice. She represents artists, songwriters, music producers, independent filmmakers on complex contracts, copyright issues, and so forth. She has worked in the past as an executive at record companies, and has a substantial background in the music area, as well as being on the Board of Governors for the LA chapter of the Recording Academy. So we have a very knowledgeable group of people. So we're going to start off with the kind of brick and mortar aspect of our discussion with Rachel. You know, this is a digital conference, so how can we get digital concepts to discuss regarding live concerts? And so we have a couple of ideas about that. And first, the ticketing system, as you guys all know probably because you bought tickets, is the ticketing system's largely digital these days, and it's really tough to get a ticket. You can go on there right the moment they go on sale, and you know you're not going to get a $45 ticket to a concert. You're going to have to turn around and go to StubHub and pay $450 for that ticket. So we're going to talk first about ticket bots. So Rachel, will you tell us what's a bot and how they work in this context?
Sure, thank you. So a ticket bot is simply a computer program that is designed to get around security checks on a ticketing platform, an online ticketing platform. And these programs have rotating IP addresses so that it's harder to tell, harder for, say, a Ticketmaster or another ticket vendor to tell when this is a person that's buying a ticket, or rather when it's a computer program. The idea being if one company can buy up 60% of the available tickets in the first 10 seconds that they're on sale, and then sell them for 3, 4, 5, 6 times the face value of them at other platforms, then it's very profitable for the bad guys, in my view, who are the scalpers. And it's really rough on fans, and in particular, it's rough on artists. So many times, fans believe that the price of the ticket that they have purchased, which is well above face value, was actually set by the artist. That's frustrating for the artist, not only because they want their fans to be able to get the tickets and not just those people who can pay a fortune for those tickets, but also it often sets them in a false bad light, because fans or people who are trying to get these tickets think that it's the artist that's gouging them.
Got it. So is this practice regulated at all? What's the law relating to bots, if any?
Okay. Well, first of all, ticket scalping itself, whether it's online or whether it's not online, is not unlawful in California unless you're selling tickets at the venue without the permission of the venue. With regard to buying tickets using bots and then reselling them, that is against the law. A law was enacted in California in 2013, and it hasn't been enforced at all. And then in 2016, President Obama signed into law the Bots Act of 2016, and that made it a crime, a misdemeanor, with a fine up to $16,000 per violation to use bots to circumvent security measures on online ticketing platforms. That statute didn't provide a private right of action, and it required state attorneys general to do the enforcing. So with respect to that law, no enforcement has occurred. There weren't financial resources that were allocated to the states for that, and there's been no case law. But furthermore, there's been just no evidence of any state doing anything to enforce these laws, either the California or the federal.
That's surprising, disappointing. Are there any protections for either consumers or artists in connection with this practice?
Well, there are companies that are using third-party online security measures. Basically, it's an arms race between the bad guys with the bots and the good guys with the bots, and so these security companies who work for ticket vendors create new software all the time that is intended to slow down or circumvent the bots that the scalpers are using. And meanwhile, all of the people coding for the scalpers are coming up with the next version to try to outwit the ticket vending companies. So there's the Ticketmaster version and the non-Ticketmaster version. So with Ticketmaster, they created a plan called the Verified Plan program, which required fans who wanted to get tickets to register 2 or 3 weeks ahead of when tickets go on sale. And that way, they sort of stalled the process and were able to look at the people who had essentially applied to get tickets and figure out, is this really a person or is it not? And they had some success. They said that they curtailed about 90% of the bot activity after the verified fan system came out, compared to how it had been. Now, that didn't solve all the problems with respect to fans and artists, because the demand for tickets in many cases still exceeds the supply. And so there were still plenty of frustrated fans even after that system rolled out. But where it was said in the press a lot that, oh, this is not working, the fans are really frustrated. Frankly, it did put a dent, at least so far, until the next versions of the software comes out, in curtailing the bot activity. With ticketing platforms that are not Ticketmaster, many of them use a third-party cybersecurity firm called Distill Networks. And Distill has been, instead of sort of profiling fans ahead of time before the sales start, rather they've just figured out algorithms to try to parse out and quarantine and remove bots at the time of sale. And that's had some success, but I don't have figures about how successful it's been. I've talked to some some smaller ticket vending platforms that are pleased with how that's been, but they're still frustrated, and they know that they have to keep updating the software every few months in order to be able to keep up, because the online ticket scalping business is an $8 billion a year business.
Wow. Wow. So it's sort of like the antivirus and anti-malware problem of keeping up with the bad guys. I go to a lot of concerts, love going to concerts. I hope I don't have to buy them from StubHub, but, another digital aspect of going to concerts these days is that I'm sure you've all seen this. Everyone in front of you has their camera up here, and basically you can't see the stage, and you end up watching the show through the people in front of you's camera, which, you could probably just do it at home if they're live streaming. But anyway, so let's talk a little bit about the use of cell phones in concerts. Is the use of cell phones at concerts like this a bad thing? How's it affecting artists and the audience, and is it legal?
Okay. Happy to answer that. Before I do, I just wanted to say one more thing about the bots thing.
Please.
It was really interesting to me because I found out about it an hour before I got here. And that was, I read in the Sacramento Bee, of all places, that in an article that was written just a couple days ago, that StubHub got raided in the UK by UK law enforcement as part of the Paradise Papers, the leak about all of the where wealthy people are hiding their money. There was a section in there that somebody caught that said, "Oh, StubHub is colluding with one of the biggest scalping organizations in the world." That wasn't a big shock to me. It's like the worst kept secret in the world that StubHub does collude with ticket scalpers. But they've always said, "Oh, I'm shocked that gambling is going on at this organization," and so So nobody's bothered to enforce these laws so far because it hasn't been that interesting. Okay, fine, arms race. Now it's interesting. Because there's a big player that isn't just doing, one at a time, that appears to be, that now there's evidence of collusion.
And there are legitimate, just folks who buy tickets and can't go to a show and resell them, and it's nice to have the secondary market.
That's true.
But it's the quantity intermediaries. And just one last question before we get back to the cell phone thing. You mentioned it's an $8 billion business, scalping business. Do you can you give us a number for the legitimate concert business annually by any chance?
I couldn't. Sorry.
Okay. I just
don't know off the top of my head.
That'd be interesting to know. Okay, so back to the cell phones. Is this a bad thing for people to be doing all this preserving of their memories and streaming? How's it affecting the audience and the artists, and what is it legal?
Okay.
Regulation of it.
All right. So these two topics sort of go together because I was feeling like doing some writing, trying to figure out, okay, what are my clients who are artists? What do they care about? What do they complain about? What needs to be fixed? So the only place they make money anymore, or most of their money anyway, is coming from touring. But there are things that are not right with touring, and they complain about ticket scalping, and they complain about once those people have worked so hard to get those tickets and get into their chairs, they're looking at my performance through a phone screen, and it's really annoying. And so for the artists, it is bad. From an artistic standpoint, they're saying, I want my audience to be able to live in the moment, hear this with their ears, and not just record it. I want them to hear this live and experience it and be with me here. The other thing is, if somebody is recording on a phone that is not going to be your best sound quality, it's not necessarily going to get your best performance, and you can't control where it gets uploaded, and once it's up, even if you do get it down, then there's 30,000 other people in the audience that also have the same recording from a different chair. And so it's very frustrating for artists. For fans, kind of depends on what their ages are for the most part. Most of them don't know that the artists would prefer that this not happen. They certainly don't know that there's anything unlawful about it, and they absolutely feel entitled. I paid a fortune for this ticket. I should be able to film the concert. So these two things aren't, terribly far apart. So fans, generally speaking, if they're filming, feel like they're entitled to do it. Artists don't want to piss off their fans. So artists have traditionally been reluctant to say, put down your damn phones. That's changing a little. So I've heard from my own clients, I've read in the trades that there are more artists that are reluctant to allow their audiences to film them without consent. They are not going to sue their fans, generally speaking, but they do want to try to exert measures to curtail the filming. What most artists don't know, unless they have a nerdy lawyer who is into this particular subject, is that it is unlawful to record a musical performance of any recording artist in the US without their consent. So pretty much everybody here is going to be familiar with copyright infringement. So if you wrote the underlying musical composition and somebody takes a photo of somebody performing that musical composition, then if you don't have a license, then it's infringement. But if you're recording somebody's musical performance and they're doing a cover tune, it's not their tune, then it's not copyright infringement, because the person who's taking the video owns the copyright in that video. They don't own the song, but it's not the performer's song. So now what? Well, there are actually two federal statutes that are anti-bootlegging statutes that I don't think people talk about a lot. I wrote an article for Billboard about it because I heard so many of my clients complaining about this practice, and I realized, wow, these artists don't know that they actually, if they wanted to, could exert a legal basis for saying, hey, this is not just uncool, it's against the law if you don't have permission. So
that article's in the materials, by the way.
It is.
So we're quickly running out of our time slot here, Rachel. So just if you could very quickly respond to a couple more questions. So
sure.
It is unlawful to make unauthorized recordings of a musical performance.
Right.
And of course, one alternative going against the fans would be going against the intermediaries that are allowing these things to be posted.
Right.
Those intermediaries, with respect to copyright, are largely insulated by Section 512, the Digital Millennium Copyright Act safe harbor provisions in Section 512 of the Copyright Act. Are those applicable to bootleg issues?
Absolutely not.
So they are potentially liable. They don't have the protections, at least, of Section 512 when it comes to that.
Right. So Section 512C, the safe harbor provisions of the DMCA, apply with respect to potential copyright infringement. But bootlegging is not copyright infringement. The applicable statute says, okay, this isn't part of the Copyright Act, but if you are guilty of doing this bootlegging and recording or distributing an artist's performance without their consent, then you're liable as if it were copyright infringement, and it refers to the damages section of the Copyright Act. But that's never actually been litigated, and moreover, damages under the Copyright Act, you can go for statutory damages if it's registered, but you can't register a performance. So I don't have an answer for that one, but what I can say is 512C doesn't apply to bootlegging.
Interesting. I have one more question, but I think maybe I should hold it for the end so we can keep moving on here. I'd love to hear more about sort of other than the anti-bootleg statutes. Are there practical measures that can be taken? And you had mentioned this Apple patented system, but if we can, let's see if we can come back around to that during the after we get through the other speakers.
Okay.
Thank you, Rachel.
Thank you.
Paul, we're going to move on into the area of the effects of the digital ecosystem or digital technology on the acquisition and licensing of music for media works. And can you give us a quick overview of the rise of streaming and its effect on the music industry and specifically on soundtrack albums? Because that's one of the businesses that you're in at Sony. Is a soundtrack album now becoming just a playlist or something? What can you tell us about that?
Here we have some good examples for that. So we're going to go to the PowerPoint. So this is a graph showing music industry revenues starting in '99 and then ending with the first half of 2017. What's interesting is that this data continues. This is all recorded music. This is data from the RIAA, which you guys are familiar with, representing the record companies. So 1999 was the largest year with recorded industry revenue, and it's $14.5 billion. It's also the same year that Napster formed. So you know what happened after that. And just to highlight a couple things, in 2001, the iTunes Store opened. In 2006, Spotify, and the numbers continued to go down until you get to 2016. And that's the first year that the industry has really seen any sustained growth. And it's 7.7 billion, which is a little more than half of what it was in '99. So the market has really shrunk. It's 52%, but it's on the way up. So it just remains to be seen where that goes. And you can see in the first half of 2017, it was $4 billion, which was 17% growth over the first half of 2016. So there's been a lot of growth, and we'll see where it ends up by the end of the year. So the sources of revenue, I just picked a couple years. I started with 2010. That's the last year that physical formats were more than 50% of the market. And you can see physical's 52%, digital downloads 38%, and streaming 7%. So still pretty small. 6 years later, streaming 51% and physical down to 22%. And digital also down from 38% to 24%. And digital's, I'm referring to downloads. The sync market I have up there, and I want to dig more into these numbers. The RIAA is not, they're not completely confident with their numbers. I mean, I feel like the sync market's grown, and I'm going to get into that a little bit later. But that's a whole separate discussion. So bringing you to the first half of 2017, streaming's gone from 51% in 2016 to already to 62%. So, and this is halfway through the year. So it's just continues to grow at a huge pace. And like I said, it'll be interesting to see where those numbers are in about a month and a half. So here's the proportion of streaming as it's grown from 9% 2011 to 62% where it was first half of this year. So some issues with streaming. There's something that people are calling the value gap. And it's really the difference in value that the user services like YouTube extract from music and the revenue that's returned to the creators of music. And that's a constant source of struggle in the industry, particularly when you look at the difference between the usage and revenue in subscription services and user-generated content services like YouTube, someone just going to watch a video on YouTube. So that's a constant source of negotiation and struggle, and it's a lot of that really is focused on YouTube, but that's an issue that has to be worked out. This chart really, it shows the value gap when you look at subscription services versus user-generated content and user-uploaded content video streams. So you look at the subscription services, they have 212 million users, and they generate $3.9 million. That's actually, that's billions. That's a billion, $3.9 billion, and that's the money that's being generated. But when you look at, and that's generated, when I say generated and distributed. So then you look at the YouTube scenario, they have essentially 900 million users versus 212 million, and yet the revenue is 553 million. So the subscription services have a quarter of the number of users, but they're producing 6 times the revenue. So you can see a huge gap there. The other gap is in terms of the money that's being distributed to the content creators. You look at the top 4 services, Spotify, Apple Music, Google, and YouTube, and they account for 94% of the market. And even though YouTube is accounting for 21% of all licensed audio streams, they're generating less than 4% of the revenue. Whereas you compare that to Apple Music, and they have 7% of the streams, yet they're producing 13% of the revenue. So you can see the imbalance there. Into soundtracks. Now this is what's interesting, and we'll talk about the playlists a little bit here. Although the record sales are down, the soundtrack sales are up 31%. So when you look at the soundtrack market, it's actually bigger. This is from 2016. It's a larger market segment than Latin and EDM, electronic music combined, which is really interesting. The numbers, obviously, it's a different scale because the market has contracted, but still the sales as a percentage are going way up. You look in 2017, 5 of the top 20 selling albums were soundtracks. Now, we'll get into the content of that a little bit later, but you can see there are 3 animated movies, and then one of those movies, Guardians of the Galaxy 2, this album was a playlist. So the main character in the movie had a mixtape. So you're thinking, why would anyone, you know, that's the argument with soundtracks is people say, why does someone want to go buy an album of pre-existing music that's already out there when they can just go on Spotify and make their own streaming playlist? Why would they buy the record? But this is a perfect example. The whole album's a playlist, and it's selling really well. We'll get to that actually in the next slide, because the music supervisor, we do Spider-Man, which is a Marvel film, and the guy who's the supervisor for Guardians of the Galaxy, those 2 records, did Spider-Man as well, and he has a really interesting take on things. 2014 is another good example where it's the first time 2 soundtracks were among the top 5 selling records of the year, and that was Guardians 1, which is almost 2 million units, and Frozen, which is 4. So you ask yourself, why? Where did it go? Oh,
That's the last slide.
I think we're missing the last.
No, that was it.
There was another slide in there. Well, I think when you look back at the soundtracks, you wonder why are the soundtracks doing well? I mean, one thing that's common among the best-selling records is there's some Disney soundtracks, and Disney is, and I work at Sony, and Disney is just in a class by itself when it comes to animated movies and creating songs and producing soundtracks. And so I think Disney is its own animal. You have compilation albums, and those are really the Guardian soundtracks that have done really well. And the music supervisor, Dave Jordan, you know, when you ask him about it, he says, you know, it sounds quaint, but the job of the music is to serve the needs of the movie first. And Dave doesn't want to approach a record label for a soundtrack deal until they're really finished doing the music for the movie. And so they really truly focus on the vision of the movie and putting the music in that's really going to work and fulfill the director's vision. and not worry about putting music in that's going to sell a soundtrack. And and I know, Jay, you worked in this industry too. I mean, the way it used to happen is a studio like Sony's producing a movie, and there's some good places for placements. And the studio will go to a record company and will say, we have some really good spots. This is going to be a music-intensive movie. What kind of advance can you pay us for the soundtrack rights? And then there will be a bidding war, and the record companies will propose an advance, and you'll make a deal with them. And then once they have these spots filled for their big artists, which creatively work for the picture, there is a creative element that you're still fulfilling under that scenario. But once those spots are filled, then it comes down to the record company thinking, well, we also have these baby bands that we just signed, and we want to put them on the soundtrack as well. And there may be a spot in the picture for those songs, and there may not be. And then there's an issue of how do you label the music? Is it a soundtrack album? Is it an inspired by album? Do you have to asterisk those tracks? So you start to kind of move away from the music that's really in the movie. And I know that's the kind of the Marvel philosophy is you really have to stay true to that. There still are single-driven soundtracks. Suicide Squad's a really good example where they had the record sold nearly 600,000 units, but they had 3 singles that they worked to help drive the sales of that record. And all those singles had uses in the picture, but the lead single sold over 2 million units. The other ones sold 800,000 and 250,000. So you can still have that model. But it is interesting that people are buying soundtracks now that are essentially a playlist.
Got it. So I imagine that the existence of digital media and digital windows in the exploitation of films and other media has altered to some extent the licensing process, the acquisition of rights, the licensing agreements, and others. How are the changes in that music ecosystem affecting the music licensing process?
Well, I mean, it's really affecting it 3 ways. First, in terms of timing. And I think Jonathan mentioned this at lunch a little bit and alluded to it. If you're looking at a music-intensive TV series and say you have an order for 12 episodes or 13 episodes, each episode is really like a feature film. And so the amount of work that's being done on each episode is tremendous. And you've got 12 or 13 feature films that are music-intensive to clear. And it's not being spaced out. The entire season is dropping it on one date. So it's different. You're not having the typical 1 episode per week clearance. You're clearing all 12 episodes right now, and then it's coming out at one time. So there's a huge amount of work that needs to be done in a short period of time. The other thing that's interesting is the timing of the soundtrack album and tying back to soundtrack albums. The label, while the TV production company's producing the series, the label is looking at a release date. So if they're going to have a release date, even if they're going to do a physical record, they're going to need the content way in advance. But even if they're going to do a digital, they're looking at the schedule and they're thinking, we need this music now. We need to start marketing the soundtrack. We need to start putting the record together. And some of the music may not even be done yet. So the soundtrack, working with the soundtrack people who need delivery now, and the production people who are producing the series, there's always an issue there. What we've done at Sony, timing-wise, is we have a 3-in-1 form where it used to be in music that you went out to the publishers and record companies with a quote request. They came back, gave you a quote, then you approved the quote, and then there's a confirmation. And the process is just back and forth, takes a long time. We now have blanket agreements with not just the major publishers and record companies, but the independents as well. Whenever we're dealing with them for the first time, we negotiate a blanket agreement, and we have a 1-page deal confirm where we can do the request, the quote request, the approval, and the confirmation in one step. So that helps with the timing. The other issue is money. I know Bill's going to talk a little bit about performance income, but you would think that with these many new sources for content, Hulu and Netflix and Amazon, that there would be a renaissance for licensing music and that sync fees would go up, and it has not been the case. The other thing you might think is that if you're Netflix or you're Amazon, you're looking at you're approaching the music publishing companies and you're saying, we should, because we have all these outlets for distribution of your content and people are watching it all the time, you're going to have all this performance income, and so we can negotiate a lower sync fee in exchange for that. And that also hasn't been the case. It's actually been the opposite. A lot of times, Netflix, not so much Amazon, but Netflix and Hulu will come to you when they're distributing one of our shows, and they will say, we want you, Sony Pictures, to clear music with a performance buyout. And so that's something that the publishers don't want to do. And if a publisher agrees to it, they're going to come back to you with a fee that's pretty high that the distributor is going to want no part of. And so what happens is, there's a constant battle between the distributor and, say, the producer of the content, Sony Pictures, and how we resolve what actually is getting used in the picture and how it's getting cleared. The end result is when you have these more platforms, you're having more sync placements, but the fee per license seems to be going down. And there are, our budgets are getting squeezed. There are advances in technology, so a lot of different people can generate music. It's not as difficult as it used to be. And you have a growth of music libraries. And music libraries, if you're familiar with, they are organizations, they're groups where they own the recording and the publishing in a piece of music. And they've taken a very active role. It's easier for a studio like us or a content creator, if we need music, we can go to a library and they can license it to you, one-stop shop. You don't have to go license a song and master separately. You can go to one place, license it, and it's usually less expensive. So you see a lot of the libraries growing up, and then you see companies like Sony ATV and publishers are buying music libraries. And then even composers like Hans Zimmer have created Bleeding Fingers Music, which is his own library, and he has composers working for him. So that's kind of from the monetary perspective. On the contractual side, which is really the third point, if I'm negotiating on behalf of Sony Pictures, I have to make sure that my deal with Netflix does not obligate me to clear music with a performance buyout, because I know that that's very difficult to do. At the same time, even though Netflix may have some control over the budget of the show, I don't want to get in a situation where I'm going back to them and they're refusing the music that doesn't have a performance buyout, and then it's changing the creative direction of the show.
Interesting. So we've kind of run out of our time. I think that maybe this last question, actually, I can posit to Bill, really, perhaps, and then that'll segue into our topics with Bill. It's been difficult. For a long time, the industry has tried to establish some system for pricing the use of music, a rate card. And it hasn't proved easy to do, let's say. And now we're in an era of big data. Lots and lots of data and information, although some users are extremely opaque with their data, as we heard earlier today. In this era of big data, are we any closer, and I'm kind of asking this to you, Bill, because I think you know about this, are we any closer to being, to doing this, or is music too malleable to be able to remove the human element from the licensing process? In other words, can data be accumulated that effectively creates a price rather than humans having to personally negotiate based on whatever concerns they have?
Well, I think we're in a gestational period. There's going to be a lot of roughness as we transition from this system that's existed for 100 plus years, where a rights owner agency clearinghouse, which controls the database of who owns all the music, morphs into the future where we have a more transactional model where many-to-many transactions are aided by computer systems. The Department of Justice asserts consent decrees over ASCAP and BMI because collective management of copyrights is a per se violation of the Sherman Antitrust Act. But the DOJ itself has recognized that at some point in the future there will be a technological evolution where many-to-many transactions can just be effectuated end-to-end, and then you don't need a blind clearinghouse in the middle. And at that point, we will be able to set market rates. But we're in a very interesting transitional period between those two things, and the powers that have organized around ASCAP, BMI, CSAC, HFA, and the collective management organizations of every territory in the world have very deep entrenched power structures and often quasi-governmental authorization or actual, legislative authority to do what they do. So getting through this path will be messy. It will not be an easy thing. But there's a long history of you can see already the outlines of where this is going, and there are already some very important legal precedents that point the way. I hadn't thought about some of the issues that you brought up here, specifically with respect to soundtracks and synchronization licensing and the effects of the on-demand streaming services, for example. And I spent a lot of time thinking about this stuff, but haven't looked at them from the angle that you're looking on. So it'd be a very interesting conversation for us to have some other time. But it isn't necessarily the case that the future will always be about buyouts of performance rights. I think that when parties come to you and ask for that, it's because the current regime, where there are these collective management organizations, and outside the United States, they tend to charge fees that are dramatically higher than what are charged in the U.S. market. They're feeling, constrained by the collusive acts of these organizations and are just looking for a clean overall solution. It's not that they don't want to pay, and it's not that they don't believe that there is a way to pay effectively in the future. It's just the current infrastructure doesn't allow that, and they don't want to expose themselves to, too much, market overreach by some of these organized parties. Our company is helping to make that transition. We are the first private entity to create a database of all the music rights ownership in the world. It's called Songdex. It's quite unique, and I mention it not as a sales point, but only to address the issue that, yes, people are often very guarded about the data that they have. But we were lucky enough to be in a position to collect data from the ASCAP and BMI databases 20 plus years ago when no one thought of data in those proprietary ways. And then we organized a group of people to research copyright information over a long period of time. And if you put enough people on that job, you can actually achieve it. And at some point, network effects begin to play back into it. The rights owners share their information with us because they know we're a responsible party. We treat them very well. We absorb their information quickly. We pay them quickly and all that stuff. And so over time, you develop a level of trust that we can be a neutral third-party arbiter of agreements between parties. And I think this is a good point to segue into the 4 bullet points that you set out for me, because I think over those 4 bullet points, I can illustrate sort of how this transition is taking place.
Good.
The first one is about live concerts and how music rights are licensed in the U.S. and in the rest of the world.
Actually, you know what? Let me pause one second. I have a question. And I should mention also that last year in this program, we covered Digital Music Licensing 101. And so we're not doing that today, as you can see. We're skipping right to the interesting new stuff, but we did include in the handouts some Music Licensing 101 materials. If some of this isn't familiar to you, please go ahead and check it out. Secondly, we talked a little bit about these OTT platforms like Netflix and Amazon. Are they still obtaining, at least in some cases, licenses from the performing rights societies, or are they completely over to a direct or source licensing system?
Yeah, no. So I'm not intimately familiar with the direct relationships between all of these parties and each other, but from where I sit, it looks like all of the streaming video companies have agreements with all 4 of the U.S. performing rights societies, which now include ASCAP, BMI, CSAC, and the new Global Music Rights, which is based in Westwood and is owned by Irving Azoff. So they all take blanket licenses from them, but are trying to deal with the fact that many of these streaming companies, Amazon, for example, Netflix, Hulu, they own or control some of the music that is in their streaming services. And so they end up paying ASCAP and then having that money come back to their organization after a delay of time and without, an admin fee taken off the top.
And traditionally, I think ASCAP and BMI, et cetera, have charged a fee based on a percentage of revenue.
Correct.
Do they still do that with an opaque sort of system like those over-the-top platforms?
Yes, they do. Interestingly, in the perennial effort to try and get more royalties for their affiliates, they look for arbitrary ways to identify, more value. And so in the on-demand streaming universe, the rates are higher than in the cable broadcast or local television space because there's an interactive component to it. And their argument is that that interactivity makes the music in the show more valuable.
Got it. So let's move back to the bullet points. This first question really kind of relates to some extent to Rachel and the live concert business. We had some conversations, and there are some changes in how music rights are licensed for live concerts, both in the U.S. and particularly in the rest of the world. Can you tell us a little bit about that, Bill?
Yeah, so here's a vignette that illustrates a pattern that is repeated over and over and over again for the last 20 years, and I could tell you many, many stories. But some managers in the UK decided to audit some of the payments that were coming through the Performing Rights Society in England, called PRS, to their composers for live broadcast in territories across Europe. So you go out on tour across Europe, whatever society is in that territory, in the Netherlands, it's Buma Stemmer, I believe, they collect money from the promoter of the concert. They pay that money back to the UK Society PRS through a reciprocal agreement, and then the society in Britain pays the composers. And if you just look at the paper that comes to the composer, you don't notice that anything's wrong. But if you go and you ask the promoter in the Netherlands what they actually paid versus what came back, what was discovered was that the promoters in the Netherlands were colluding with the local society in the Netherlands to have a kickback. So they would pay X dollars, but then they would get that some of that money back. And then the society would pay PRS, less this kickback, and PRS didn't even know the difference, right? And so they passed that money through their composer without any awareness of this. When this was revealed to the PRS organization, they kind of shrugged. They said, well, we should do something about that, and then they didn't really do anything about it. So the managers got angry and formed an organization called PACE Rights Management, which uses a provision of the collective management laws in Europe to withdraw the rights for live performance from the local societies for the duration of the tour. In other words, the composers basically take those rights back to themselves, and they make it their own business to deal with the promoters through this PACE organization. And then as soon as their tour is over, they go right back into the PRS organization for any future performance rights. What happens, therefore, is that they are able to directly negotiate with the promoters, which has its own dramas, and you would only do this if you thought there was something really worth doing. But after you accounted for the admin fees charged by PRS and by Buma Stemmer and the kickbacks given to the promoters, there was a significant leakage in the money that was coming back to them, and so doing a direct deal made more sense. So as long as you have an organization like PACE Management that can organize these direct deals, it's much more efficient to go direct. And this is the essence of what's happening. The collective management organization pattern of licensors, clearinghouse, licensees is breaking down as the licensors and licensees meet each other around the side and do direct deals to avoid the admin fees and the delay created by the clearinghouse.
Got it. It's complicated. And something like that is something like that happening in the U.S. as well?
Well, I mean, we would also say it's complicated to open up your phone and hail a car that is driven by a person you've never met before, but who you can rely upon to show up in seconds and take you anywhere you want to go and transact without ever having to touch a credit card.
You can do that?
It's like black magic, right? So the technology is here, yeah.
Oh, cool. So there are all kinds of other new players in the music rights space, and so I wanted to ask you to tell us a little bit about some of them. What's global rights management? I think you mentioned it previously, but what's global rights management?
It's actually global music rights,
Global-
GMR.
GMR, sorry.
This is the new society organized by Irving Azoff. Irving, of course, is a famous rock manager, very involved in live ticketing and live promotion and all aspects of that business, all the way down the vertical, right? Very smart guy, and he recognized that the collective management organization business is a pretty straightforward business. You acquire some very important composers that no one can do without, and then you create a collective management organization around them, and then you go to the licensee communities and you say, you must pay me because I have the exclusive rights to public performance for these artists. They had the Eagles, they have Pharrell Williams, they have a whole bunch of unavoidable artists. And they basically followed a rule book that was laid down by CSEC 20 years ago, which did the same thing with Rush and Bob Dylan and a bunch of others. Now, most famously, CSEC now has Adele, which makes them, bulletproof, right? There's nobody who can avoid playing Adele, so everyone must take a CSEC license now. So that's what that game is. You sort of the difference between GMR and ASCAP, BMI, and CSEC is that GMR is hyper selective. They don't want a giant collective of rights owners. They want a small stable of extremely valuable composers because it's easier to administer. I think it's really important when you're thinking about the music business in particular, but probably any kind of entertainment, to bear in mind that there's a power law curve that defines the distribution of content. There are 2% of the songs in circulation drive 98% of the royalties, and 98% of the songs drive 2% of the royalties, and 80% of those songs don't even get played at all. So it's an extremely sharp business. If you can focus your business on just the head of the snake and not worry about all the administrative nightmare of the long tail, it's fantastic for you, and that's exactly what GMR's business model is.
Interesting. Yeah. I don't know if we have enough time for it. We do have a couple of questions to ask from the audience, but there was one more acronym I wanted to ask you about, and I also wanted to, in particular, ask you about this new legislative program that the National Music Publishers Association is proposing to deal with rights licensing. So maybe we can, if you could tell us briefly, what's global repertoire? What's the global repertoire database? And then we can talk about the NMPA legislative proposal.
Right. So the global music ecosystem is super complicated. There's a 2-pager in the packet that, if you're interested at all in this stuff, is, I think, helpful. It gives you a sense of what the terminology works at. There are, of course, sound recordings and musical compositions, and they are licensed differently. Sound recordings have a metadata row associated with them: title, artist, album, ISRC, etc. And compositions have a different metadata row associated with them: title, composer, publisher, ISWC, etc. And if you notice, they only overlap in the title field, but there's no law against having the same title for multiple songs. So disambiguating the world's repertoire of music is a super difficult problem. In addition to which, that long tail of composers, and there are 1 million new tracks a month coming into the global ecosystem through the modern, self-help systems like TuneCore, CD Baby, DistroKid, etc. Those people don't even know that they're music publishers. They know that they're a band and they have a song and they want to get it distributed on Spotify, but they don't know, oh, I'm also a publisher and a composer, and I have a separate metadata row that I have to populate into a global registry system. And so everyone has recognized for a long time that if there were a single global registry of music rights information, that rights and royalties for music would flow much more efficiently. Licensing would be less risky for licensees. Payment would be less risky for licensors. And so everyone has been trying to get there, but the parties all have conflicting interests and don't have any real incentive to collaborate on this. So WIPO tried to create an international music registry. That failed. A bunch of private sector organizations, quasi-governmental or collective management organizations, tried to create a global repertoire database. That failed when ASCAP and BMI pulled their funding. So these efforts through multilateral organizations have not been successful. At the same time, our organization as a private entity has just quietly been building this database on our own, and at this point we effectively are the global repertoire database.
Interesting. And finally, you had mentioned that there's this new legislative program to deal with the complexities of music licensing called, I think it may be called Song Exchange, and I wonder if you'd like to tell us a little bit about that and whether and your evaluation of that, whether that helps with the transparency issues in the existing system, for example.
Great question. So if you're familiar with Sound Exchange, when 114 established the sound recording performance right in 1995, the record companies got together and organized an organization called Sound Exchange, designed to collect and manage the sound recording performance rights. A licensee need only send one notice to Sound Exchange, and they immediately have access to all of the repertoire of all the record companies for certain defined uses. And at that point, they just have to send reports annually, or monthly actually, to Sound Exchange, and it can process those and send the payments to the phonogram producers and the performers on those recordings. The publishing industry wanted nothing to do with this in 1995. In fact, they made sure that the law said that this would not impact their part of the pie, and that the precedents set by that industry could not affect their rate-setting standards.
Thus protecting ASCAP, BMI, the existing...
Because they had a good thing going at the time. Yeah. But now the world has changed so much, and digital streaming has come on so strongly that the thought is the big streaming services like Spotify, which is suffering a $350 million class action litigation, hasn't got enough risk protection in the market by trying to deal with 67,000 publishing administrators on its own. And at the same time, the rights owners are not getting paid effectively, especially the people in the long tail who aren't very effective at registering their rights. And so the DEMA, the Digital Media Association, and the NMPA are cooperating on a legislative initiative which would take us back to an analogous system to Sound Exchange called ostensibly Song Exchange, where you would simply, Spotify would ask for a single license from the NMPA or from Song Exchange, and in exchange they would have a right to use all the songs in creation, and then it would be up to the publishers and the collective management organizations to fight it out behind the scenes of this Song Exchange organization to figure out who owns what. The problem with that model is it's the antithesis of the transparency that everything is moving toward at this point, because once you again have a clearinghouse with a black box in the middle that decides arbitrarily who owns what and how to pay everybody, you misalign the incentives to actually work out the data. And so at the end of 3 years, anything that doesn't match simply gets liquidated to the major rights owners according to their market share. And at that point, there's no incentive to try and figure out who owns anything, because anything that doesn't match in 3 years, it's just going to go out in the wash. That is opposed by our company, which has a clear transactional model, end-to-end. We can tell every stream where it came from, what the royalty rate was for it, account for it transparently, and settle the payments for it without any friction at all. And our system is already supporting almost all the streaming services in the United States, with the notable exception of Spotify. So our proposal would be to see if the policymakers can't let the free market solve the problem, which it already has, rather than legislate back into a black box.
So we may have to revisit that one next year. Thank you, Bill. We need to save a few minutes for questions, and we really only have, at this point, one, although I personally was waving my hand back there during other conversations, so, you know, if you're not into texting, feel free. Meanwhile, we really have two questions, but they both deal with the same thing, essentially, which is kind of, well, that's not the one. All right, show, hide. Okay, so much for the tech here. There we go. They really both relate to blockchain technology. And whether, and this print is so tiny, but when will copyright ownership and licensing and royalties go onto the blockchain, eliminating intermediaries and unnecessary transactional costs? And that they raised that question probably for perhaps Bill, and then the same for ticket sales. Can the blockchain problem solve that scalper's problem? So, Bill, would you care to comment on the first part?
Yeah, well, so briefly, you know, blockchain is a term often used for a larger set of principles called distributed computing, which is almost certainly the future of database and network computing. That's just where the world is going. But we're not going to be there for the next 5 to 10 years. And in the meantime, absolute transparency and auditability is absolutely possible with intermediaries. The problem with the current intermediary system is not that there's intermediaries, it's that those intermediaries are self-interested and competitive. Whereas our company represents a neutral transaction model that's transparent and auditable. So that's that difference. What I would ask about that as well is the idea that transactions can happen without intermediaries at all. How would that work in the sync licensing space? You know?
Well, I mean, that goes back to kind of the rate card situation, and your you know, there's a lot there in every license. There's the term, there's the territory, there's the type of use, and then there's the piece of music. And so how can you set a value on the use, and first of all, how do you set a value on a song? And do you look at sales, and can you set an arbitrary value based on songs or sales and streaming? And then how do you put a value on the actual use in the production? And I don't know that you could ever do that.
And how do you stop the guy from coming in at the last minute and going, you know what, I want twice as much, right? Because-
Exactly.
So I may not fully understand blockchain. That's an understatement. But I look at it as I've heard about it. I've heard it discussed as a system for payments. But it sounds like it might also be a system to calculate other things. So, for example, if blockchain technology can determine some other sort of sales success for a song and then somehow mute that into a price, is that something that, I guess that would automate the pricing system like we talked about? Is that just too far in the future for us to get into?
I think it's really far down the line. And I don't know, I think in the context of film and TV licensing, I don't know that it could ever get to that point. I think it would be really difficult.
And is there a subjective component anyway in terms of what you're willing to pay for a song and versus the alternatives pieces of music you could use? So really, it's not purely data analysis. There's something, like Jonathan said at lunch today, there's thank goodness still some room for human creativity in this process, and maybe AI won't be eating this part of the life up anytime soon. And Rachel, any thoughts on whether this blockchain technology is being used or could be used in terms of ticket sales and concert tours so that it could possibly help with the scalper problem?
To my knowledge, it's not being used currently, but all of the ticketing platforms are looking very seriously at it, and it is absolutely expected to be part of pricing solutions, part of security solutions, a big part of trying to get these evil intermediaries out of there. But with touring. Touring consumers or ticket buyers have wildly fluctuating demographics. And so where consumers who are streaming music tend to skew younger and more technologically savvy, in the touring world, you have lots of people who want to go see Celine Dion and Garth Brooks who are not part of that world. And some moms and dads that want to buy tickets for their youngsters. And so for blockchain in the ticketing world to be effective, it's going to have to be largely invisible to the consumers. And so that's part of the challenge.
Interesting. And I'll wrap this up with an Orwellian thought for future of purchasing tickets for music concerts, which would be biometrics. Tell the someone how much I'm enjoying the concert, and if I'm liking it a lot, they charge me extra. And if I'm hating it, then they give me a little bit of a refund. Maybe they give pricing based on how much your utility is, how much you're enjoying the concert. I don't know. I hope that's a long way off in the future. But would you join me in thanking our panelists today? And please stick around for the party.